Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Welcome to the Arbitration World podcast. My name is Chris Valente, an international arbitration and commercial disputes partner in the Boston and Washington, D.C. offices of K&L Gates. We're pleased to bring you this series of podcasts on key cases, developments, and trends in the United States that are having an impact on international arbitration in the U.S. and across the globe. On this episode, we'll discuss the impact that state anti-arbitration insurance statutes have on the enforceability of international arbitration clauses found in insurance policies. We've also recently written on this topic, and you can find the article along with other international arbitration content in the Thought Leadership section of our International Arbitration Practice Group's website at klgates.com. Joining me on this podcast today are my colleagues, Jackie Celender, Mike Creta, and Peter Ayers. Jackie is a partner in the K&L Gates' Pittsburgh office and a member of the International Arbitration Practice Group. Throughout our careers, Jackie and I have represented policyholders in a variety of coverage matters. So this particular intersection of international arbitration and insurance coverage has been really interesting to think about. Also joining us is Mike Creta and Peter Ayers, both associates in our firm's Boston office with experience in international arbitration and insurance coverage. Okay, so let's dig in. First, we're going to provide a summary of the current state of the law and then discuss some of the implications for policyholders, and in particular, policyholders who have entered into insurance policies with non-U.S. insurers that contain international arbitration clauses. The central issue here is whether state anti-arbitration insurance statutes reverse preempt the New York Convention and bar insurers from enforcing arbitration clauses in insurance policies. To answer this question, policyholders need to look at state anti-arbitration statutes, the McCarran-Ferguson Act, a U.S. federal statute, the New York Convention, an international treaty codified into federal law, and the U.S. Constitution, and then figure out how they all interact with one another to form the governing law. Further complicating this matter is that the Ninth Circuit has recently created a circuit split on this issue. So, to untangle the state of the law, Jackie, could you walk us through the various sources of law here?
Yeah, sure, Chris. Absolutely. It's great to join all of you today. First, it's important to note that in general, the Supremacy Clause of the U.S. Constitution mandates that state law give way to conflicting federal law, which includes international treaties to which the U.S. is a signatory. One such treaty that's of significant importance to this issue is the New York Convention, which generally commits the U.S. to a national policy of recognizing and enforcing arbitration agreements when foreign entities are involved. It's well understood that if the New York Convention and state anti-arbitration insurance statutes were the only provisions at issue, the state laws would be preempted by the New York Convention under the Supremacy Clause. But while the Supremacy Clause is the general rule, the McCarran-Ferguson Act carves out an exception to the Supremacy Clause by providing that state laws enacted for the purpose of regulating the business of insurance do not yield to conflicting federal statutes enacted by Congress unless the federal statute specifically relates to the business of insurance. So if the New York Convention is deemed to be an act of Congress under the McCarran-Ferguson Act, in states where anti-arbitration insurance statutes exist, the New York Convention would be reverse preempted by the state laws. And this would effectively bar foreign insurers from enforcing international arbitration clauses in insurance policies. The question that lies at the center of the circuit split is whether the New York Convention is a self-executing treaty and therefore not an act of Congress under the McCarran-Ferguson Act, or whether the convention is a non-self-executing treaty that relies upon the Convention Act, which Congress passed in 1970 to amend the Federal Arbitration Act to include the contents of the New York Convention for its implementation.
Thanks for that overview, Jackie. As mentioned, a recent Ninth Circuit decision from 2021 CLMS Management Services held that state anti-arbitration insurance statutes do not reverse preempt the New York Convention. The Ninth Circuit's decision formed a circuit split with a 1995 Second Circuit decision. I'm going to turn it over to Mike and Peter to talk a bit more about the background and holding of CLMS Management Services and the earlier Second Circuit decision. Mike?
Thanks, Chris. I'd be happy to talk about the Ninth Circuit's decision. But before getting into the cases, I wanted to note that while the current circuit split is only between two circuits, over a dozen U.S. states have enacted laws prohibiting mandatory arbitration clauses in insurance policies, and the current split could expand. CLMS Management Services involved a dispute between a policyholder and its foreign insurer arising from a townhome community's insurance claims related to damages it sustained during Hurricane Harvey in 2017. The insurer attempted to compel arbitration of the dispute under an arbitration clause in the insurance policy. However, the policyholder argued that the insurer was barred from enforcing the arbitration clause under Washington's state anti-arbitration insurance statute. The district court disagreed with the policyholder and granted the foreign insurer's motion to compel. The Ninth Circuit ultimately affirmed the decision of the district court to compel arbitration. With regard to whether Washington's anti-arbitration insurance statute reverse preempted the New York Convention, the Ninth Circuit held that the New York Convention was a self-executing treaty that did not rely upon the Convention Act for its implementation. As a result, the court found that the McCarran-Ferguson Act was not applicable and that Washington's anti-arbitration statute was preempted by the New York Convention under the Supremacy Clause. In determining whether the New York Convention was self-executing, the Ninth Circuit looked to the New York Convention's text as well as the shared expectations of the contracting parties to the convention. Following the Ninth Circuit's decision, the policyholder filed a petition for a writ of certiorari, which the Supreme Court denied in January of this year. I'm going to turn things over to Peter to briefly discuss the Second Circuit's conflicting decision, Stevens v. American International Insurance Company.
So, like in CLMS Management Services, the Stevens case involved a foreign insurer's motion to compel arbitration of an insurance dispute in a state that had an anti-arbitration insurance statute. However, unlike the Ninth Circuit, the Second Circuit held that the New York Convention is a non-self-executing treaty because it relies upon the Convention Act for its implementation. Accordingly, the court held that the insurer was barred from compelling arbitration because the state statute reverse preempted the New York Convention under the McCarran-Ferguson Act. In reaching its conclusion, the Second Circuit largely relied upon the existence of the Convention Act to find that the convention was non-self-executing. I also want to briefly add that in addition to the Second and Ninth Circuits, the Fourth and Fifth Circuits have also discussed whether the New York Convention is reverse preempted by state anti-arbitration statutes, but ultimately did not decide the issue as they were able to reach their conclusions on other grounds. In both decisions, the Fourth and Fifth Circuits discussed the competing views on the issue and found that proponents of both the Second Circuit approach and the Ninth Circuit approach have valid and reasonable arguments in support of their positions.
Thanks, Mike and Peter, for that summary. Now, let's turn to the tougher part. What does this circuit split mean for policyholders who have insurance policies with international arbitration clauses? Well, there's certainly more uncertainty. State anti-arbitration statutes, like most insurance laws, are intended to protect policyholders. Given the Supreme Court's denial of the policyholder's petition for writ in CLMS, this will remain an unresolved area of law for the foreseeable future. As Mike mentioned, only 2 of the 12 federal circuits have issued decisions on this issue. This leaves very little precedent in case law for policyholders to rely on for guidance. Absent new circuit court decisions or a wider circuit split that causes the Supreme Court to reevaluate its decision not to weigh in on this issue. Given the lack of guidance, predicting how this issue will be handled in the future is certainly challenging. U.S. policyholders should check. Do you have international arbitration clauses in your policy? It's imperative that policyholders be aware that even if the state whose law governs their insurance policy has an anti-arbitration insurance statute, it does not necessarily ensure that the statute will be enforced. If you're subject to an international arbitration clause in your policy, there may be additional considerations. Jackie, could you walk us through some of what those may be?
Yeah, of course. The first point that we need to recognize is the importance of understanding which federal circuit's law may govern your policy. Some policyholders may receive the protection of state anti-arbitration statutes where they exist, while others will be forced to arbitrate insurance disputes with foreign insurers, regardless of whether there's a state anti-arbitration insurance statute. Forcing arbitration in insurance disputes with foreign insurers could have significant effects on policyholders, as arbitration with foreign insurers can sometimes take place in remote locations with little connection to the underlying dispute. And this could make resolving an insurance coverage issue more burdensome and expensive for policyholders than if they were able to litigate the dispute in a local court. One other high-level takeaway is that policyholders should pay particular attention to arbitration clauses and choice of law provisions contained within their policies to determine whether state anti-arbitration insurance statutes exist under the governing law and the likelihood of those statutes being enforced against foreign insurers. The likelihood of an arbitration clause being enforced is an important factor for policyholders to be mindful of when making strategic decisions concerning whether, when, and where to initiate an action.
Those are all great points, Jackie, and ones that I know we've both counseled clients on.
Yeah, so Chris, why don't you walk us through some of the trends we should keep an eye out for?
Well, one thing I would add is that while only 2 circuits have addressed whether these statutes preempt or reverse preempt the New York Convention under the McCarran-Ferguson Act, more courts are likely going to weigh in on this issue in the coming years, particularly as the frequency with which arbitration clauses appear in insurance policies, particularly international arbitration clauses, and because international arbitration is becoming increasingly popular. At some point, the circuit split will catch the attention of the Supreme Court. However, until then, policyholders should just continue to be mindful of the issue and consult with counsel when making those strategic decisions.
Yeah, thanks, Chris. I think that both policyholders and practitioners are all likely hoping for some further guidance on that. And regardless of how courts come out on the issue, increased clarity one way or another would certainly benefit policyholders.
Couldn't agree more. Well, that's all we have for today. Thank you for joining us on this episode of Arbitration World Podcast. We hope you'll continue to listen and read our thought leadership in the international arbitration space. If you have any questions about any of the topics addressed today, please don't hesitate to contact us. And if you have any comments or topics that you would like for us to discuss on future episodes, please feel free to reach out and let us know. Thank you.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.